Alright, hi, U.S. Code 2011, Title 15, Chapter 63, Section 7310A. Section 3710A. 3710A Cooperative Research Development Agreement. It's General Authority. Each federal agency may permit the director of any of its government-operated federal laboratories to extent provided with an agency-approved joint work statement and, if permitted, with the agency, an agency-approved annual strategic plan. An agency approved with the analytical strategic plan, the director of any of the government-owned contracting-operated laboratories. To enter into cooperative research development agreements on behalf of such agencies subject to subsection C of this section with other federal agencies, units of state or local government, industrial organizations, including corporations, partnerships, and limited partnership and industrial development organizations, public and private foundations, nonprofit organizations, including universities, other persons, including licensees, inventions owned by federal agencies, and to negotiate license agreements under the Section 207 Title 35 under the authorities in the case of government-owned contracted operated laboratory, subject to subsection of the C of this section for the inventions made by the other intellectual property developed at the laboratory, other inventions, other intellectual property that may be voluntarily assigned to the government. Alright, Section 63, Title 15, Chapter 63, Section 3710A, 3710B. Under the agreement I entered in the pursuant to subsection A1 of this section, laboratories may grant and agree the grant in advance to collaborating party and patent licensing assignments and optional thereto to any invention made whole and part of the laboratory employed with under agreement subsection to the Title 209 of the Title 35 may grant a license at invention which federally owned for which the patent application was filed before signing the agreement directly with the scope of the work under agreement for reasonable compensation appropriately. The laboratory shall ensure through its agreement that the collaborative party that has option to choose an exclusive licensing pre-negotiated field of use for each of such invention under the agreement, and there's more collaborating party. There's collaborating parties that are offered to the option of holding license rights that collectively encompass the rights that would be held under such an exclusive license by one party. In consideration, government contribution under the agreement grants or under the paragraph or the subset shall be subject to the following explicit conditions. A non-exclusive, non-transferable, irrevocable, paid-up license from collaborative party of the laboratory to practice invention, or have invention practiced through the out of the world or behalf of the government. In exercise of such a license, the government shall not publicly disclose trade secrets or commercial financial information that has been privileged confidential within means of Section 552. B4 and Title 5, which would be considered as such part had been obtained with a non-federal party. B. If laboratory signs title or grants an exclusive license to such an invention, the government shall retain the right. Alright, to require the laboratory require collaborating party of the grant responsibility application non-exclusive, partially exclusive, and exclusive license to use invention in the applicant's license field of the use, terms of the reason under the circumstances if the collaborating party fails to grant such license to grant the license itself. The government may exercise its right to retain the subparagraph B of only in the exceptional circumstances only in the governmental determines that 1. The action is necessary to meet the health and safety standards and not reasonably satisfied by the collaborating party. 2. The action is necessary to meet the requirements publicly specified by the federal regulations. Such requirements are not reasonably satisfied in collaborating party. 3. The collaborating party has failed to comply with the agreement containing with the provisions described in subsection C4B of this section. The determination is subject to the administrative appeal and judicial review under the section 2032(1) of Title 35. 2. Under agreements entered in the pursuant subsection of this section, the laboratory shall ensure the collaborating party may retain title to any invention made solely by its employee in exchange for the normally granting the government non-exclusive, non-transferable, revocable, paid-up license to participate in the inventions that have invention practiced throughout the world on the behalf of the government for the research of the government purposes. Under the agreement that entered into pursuant subsection A1 of this section, the laboratory may A. accept, retain, use funds and personal services property for the collaborating parties provide with the personal services and property of collaborating party. B. Using funds received by the collaborating party in accordance with subparagraph A and the hire personnel to carry out the agreement who will not subject the full-time equivalent restriction of the agency. C. The extent of the consistent with the application agency requirements of the standard of conduct permit the employee or former employee to the laboratory to participate in an effort to commercialize invention made by the employee, former employee while in the employment service of the government. D. Waive subject to the reservation of the government non-inclusive, irrevocable, paid-up license to practice the invention or have a invention practiced throughout the world by and behalf of the government in advance with the whole and part of any right or ownership which the federal government may have to any subject invention made under the agreement by the collaborating party and employee collaborative party. 4. The collaborating party is an inclusive license and the intervention may be under the agreement entered into pursuant subsection A1 of this section shall have right to enforce under the Title 29, Title 35. 5. Government-owned, contracting, operated laboratory had entered into the cooperative research development agreement in pursuant to subsection. This section may use the obligation of royalties and other income accruing to the laboratory under such agreement with respect to any invention only. A. For the payments of the inventor. B. The purpose described in clause 1, 2, 3, 4 in the section 37010 C. A1B of this title. Alright, C. The scientific research and development consistent with the research and development missions and objects of the laboratory. 6A. In the case of the laboratory that is part of the National Nuclear Security Administration, designated official administrative may waive the license retained with the government under paragraph 1A, 2, and 3D and whole part of the according to the negotiated terms, and if designated official find the retention for the license by the government who substantially inhibit the commercialization of an invention that would otherwise serve as an important national security mission. B. The authority to grant the waiver under the subparagraph it shall expired on the date that the 5 years after the October 30th, 2000, the expiration under the preceding sentence for the authority to grant the waiver under the subparagraph 8 it shall not affect the waiver granted under the subparagraph before the expiration of such authority. C. Not later than February 15th of each year, the Administrator of Nuclear Security shall submit the Congress report of any of the waivers granted for the paragraph during the preceding year. Alright, C. Contract considerations. 1. Federal agency may issue the regulations suitable for the procedures implementing the provisions of this section. However, the implementation of this section shall not be delayed until the issuance of such regulations. 2. The agency is in permitting with the federal laboratory to enter into the agreements under this section shall be guided with the purpose of this chapter. 3A. And the agency using the authority given with the under subsection A of this section shall review the standard conduct of the employees for the resolving potential conflicts of the interest to make sure they adequately establish the guidelines for the situations likely to arise for the use of this authority, including but not limited to the case of presenting former employers or their partner negotiated licenses, assignments, title inventions, and negotiated cooperative research development agreements of the federal agency, including the agencies with the employee involved with the formerly employed. B. The implementing subparagraph A agency is unable to resolve the potential conflicts interesting the current statutory framework. It shall be purpose of the necessary statutory changes to be formed in authorization committees in the Congress. 4. The laboratory directive is deciding the cooperative research development agreement to enter into shall give special consideration to small business firm consortia involved with the small business firm. And B. Give the performance of the business units located within the United States which agree with the products embodied with the inventions made under the cooperative research and development agreement produced through the use of such an invention will be manufactured substantially in the United States. In this case, any of the industrial organization or other person subject. to the control of the foreign company of the government as appropriate, with the take consideration whether or not foreign government permits the United States agency, organization, other persons to enter with a cooperative research development agreement with the licensing agreement. 5A, if the head of the agency is designator desires the opportunity to dissolve, require the modification of such agreement, the presiding with the director of the government, the operating with the laboratory agreement shall be provided in 30-day period, which when the such action must be taken with the beginning of the date of the arrangement and the presented with him or her by head of this laboratory concerned. B. In any case, in any case which the head of the agency, the designator, approves, requires the modification of the agreement presented with the director of the government operated laboratory under this section, the head of the agency, such as designee shall have to transmit a written explanation of this disapproval modification to the head of the laboratory concerned. C1. Any non-federal entity that operates a laboratory pursuant to the contract of the federal agency shall submit the agency any of the cooperative research development agreement that entire entity purposes to enter into and the joint working statement and required with respect of this agreement. 2. The federal agency received the proposed agency agreement in the joint work statement under this clause shall review the approve and request the specific modifications to disapprove the proposed agreement, the joint work statement within 30 days after the submission. No agreement may be entered in the government owned with the contractor operated laboratory under this section before both approval of the agreement and the approval of the joint work statement is under the clause. Title 3. In any case in which the agency which has the contractor within the entire entity referred to in clause the disapprove the request of the modification of cooperative research development agreement, joint work statement submitted under this clause, the agency shall transmit in writing the explanation should it disapprove of the modification of the head of the laboratory concerned. Laboratory concerned. 4. An agency with a contract with the non-federal entity to operate with the laboratory may be developed and provide such a laboratory in one more model cooperative research development agreements for purposes of standardization, practice and procedure, resolving the common and legal issues, and enabling the review of the cooperative research development agreements to be carried out in routine and prompt manner. 5. A federal agency may waive the requirements for the clause in 1 and 2 under the circumstances for the agency considered with the appropriate. 6. The agency shall maintain a record of all the agreements entered into under this section. Under the section 7A, no trade secrets, commercial or financing information privileged and confidential under the meaning of the section 552B4 of the Title V obtained with the conduct of the research with the result of the activities under the chapter of non-federal party participating in the cooperative research development agreement shall be disclosed. B. The director, in the case of the contracting operator of the laboratory with the agency's period up to the 5 years of developing information that results with the research and development activities conducted with the chapter that would be in trade secret, the commercial, financial information privilege with the confidential with the information that had been obtained with the non-federal party participating with the cooperative research development and may provide with the appropriate protections against the disseminating of such information, including exemptions from subchapter 2 of chapter 5 of the Title 5. Alright, definitions. Used in this section, the term Cooperative Research Development Agreement means an agreement between one or more federal laboratories, one or more of the non-federal parties under which the government through the laboratories provides personal service facilities, equipment, and intellectual property, other resources without reimbursement, but no funds with or without reimbursement. Definitions in terms. Using this section, in the term the Cooperative Research Development Agreement means an agreement between one or more federal laboratories, one or more federal parties under which the government through its laboratories provides personal service facilities, equipment, and intellectual property, or other resources without reimbursement, but no funds to non-federal parties, and the non-federal parties provided with the personal service and the facilities, equipment, and intellectual property, or other resources toward the conduct of specified research development efforts which are consistent with the mission laboratory, except for such term does not include the procurement contract and cooperative agreement in such terms as section 6303, 6304, and 6305 in Title 31. A. The term laboratory means a facility group of the facilities owned and leased otherwise used by the federal agency, substantial purpose of which was performance of the research, development, engineering, and employees of the federal government. B, the group of the government owned both the contractor operated facilities, including weapon production facilities, development, and energy under the common contract, which the substantial purpose of the contract is performance of research, development, production, maintenance, testing, and dismantlement of a nuclear weapon and its components for the federal government. C, a government-owned, the contractor-operated facility, including the weapon production facility in the Department of Energy that is not under the common contract described in subparagraph B. The primary purpose of this performance, research, the development, the production, maintenance, and testing, and dismantling of a nuclear weapon or its components for the federal government. But such terms do not include the facility covered with the Executive Order Number 123444, dated February 1st, 1984, pertaining to the Naval Nuclear Propulsion Program. The term Joint Work Statement means that the proposal prepared with the federal agency but made with the director owned with the contractor-owned operative laboratory, describing the purpose and scope, provided with the cooperative research development agreement, and assigned. E. Rights and responsibilities among the agency, the laboratory, any of the parties to propose the agreement. For the term weapon production facility of the Department of Energy means the facility under the control of jurisdiction of the Secretary of Energy that is operated within the national security purpose of engaged production, maintenance, and testing, dismantling of a nuclear weapon and its components. Either determining a laboratory mission for the purpose of this section, agency shall make separate determinations of the mission of each of the laboratories. F. Relationship to other laws. Nothing in section is intended to limit the diminishing existing authorities to agencies. Principles. Implementing these sections, such as agencies shall be contracted with non-federal entities to operate the laboratory and shall be guided with the following principles. 1. Implementing shall advance the program missions of the laboratory, including the national security mission. 2. Classified information, unclassified sensitive information protected by law, regulation, executive orders shall be appropriately safeguarded. And the rest is pretty much a review. Is a review of cooperative research development agreement procedures. All right, we're gonna read 3710B. I think that's that was Title 15, Chapter 63, Section 3710B. Sorry, 3710A.